Welcome to Mayor Brown's Global Financial Markets Podcast. Each 30-minute episode is designed to help listeners better understand the legal issues that impact their business given the ongoing uncertainties in the financial markets worldwide. Speakers from across Mayor Brown's practices and offices provide their timely insights on a wide range of topics, including finance, financial services, and insurance regulatory developments, securitizations, and litigation in the United States, the United Kingdom, Europe, and Asia. We hope you enjoy the program.
Hello, listeners. Our topic today is SEC reproposes conflict of interest rule for asset-backed securities. And we will be focusing on providing a little brief historical context for this rule, as well as a general overview of the proposed rule. My name is Paul Forrester. I'm a partner in Mayor Brown's Chicago office and a member of the firm's banking and finance group. Joining me today are the other authors of our related legal update, to which we would obviously refer you if you have questions and want a more detailed review of today's subject matter. My co-presenters today are Leslie Cruz, who is counsel in Mayor Brown's Washington, D.C. office and a member of the firm's corporate and securities practice. Chris Horn, counsel in our New York office and a member of the firm's banking and finance practice. Stuart Litwin, partner in our Chicago office and a member of the firm's banking and finance practice. And last but by no means least, Michelle Stasny, counsel in our Washington, D.C. office and a member of the firm's banking and finance practice. Unfortunately, in today's GFM podcast format, we will only be able to cover a few selected topics at a relatively high level. And as I just mentioned, if you want a more detailed review, we encourage you to check out our related legal update that was published on January 30 and is available on mayorbrown.com under the Perspectives and Events tab. To get us going today, Stuart, would you spend a few minutes giving us a little history for the rule and then turning to a general overview of what the proposed rule would prohibit?
I'd be glad to, Paul. Thanks very much. So the rule started with Section 621 of Dodd-Frank. And when this was adopted, it was a reaction to the Goldman Sachs Abacus transaction, in which John Paulson selected a number of mortgage-backed bonds to include in a CDO. And then Goldman allowed John Paulson to short that CDO, and effectively a transaction that was designed to fail, and then John Paulson made a lot of money when the transaction in fact did fail. And so the statute directs the commission to adopt rules to prevent conflicts of interest in securitization transactions. And the commission proposed a set of rules in 2012, and the comments on that basically were that the proposal was completely unworkable. It just didn't make sense, and so the commission put it on hold. But in the very recent, past couple of months, the commission is now pulling out their mandates under Dodd-Frank, and they're required to create rules, and now they're going to try and get this one out of the way. So they have reproposed new rules to under Section 621 of Dodd-Frank. The new proposal would create a new Rule 192 that would prohibit a securitization participant in an asset-backed security from directly or indirectly engaging in any conflicted transaction during an applicable period. So I think, that's in one sentence, this entire proposal. And so we're going to focus on each of the individual elements. So what are some of those elements? Number one, what are the asset-backed securities that it applies to? Number two, who's a securitization participant? Number three, what are the conflicted transactions that are going to be prohibited? And then number four, what's the period that those transactions are prohibited in? And then finally, there is a directly or indirectly, and there's an anti-evasion clause that even further broaden this potential prohibition. So let's start with the asset-backed securities. It applies to both registered and unregistered asset-backed securities. It's public or private, it doesn't matter. And it also explicitly includes synthetic asset-backed securities. And that's a real problem for a lot of folks who are going to be who are thinking about capital relief transactions of different sorts. Okay. Who's a securitization participant? That is an extremely broad definition. It includes sponsors with a new definition of sponsor that's different and broader than other definitions of sponsor under other rules. Also includes underwriters, initial purchasers, placement agents, and for all of those folks, it also includes their subsidiaries and their affiliates. So wherever their affiliates may be, inside the U.S., outside the U.S., you have to keep track of those folks and make sure that they don't enter into the conflicted transactions. Much broader definition of sponsor. It includes any person that has that causes or has a contractual right to cause the direction of the structure, design, or assembly of an asset-backed security. This definition is so broad in part because the Commission is reacting to the LSTA case that said CLO collateral managers in open market CLOs wouldn't, that risk retention wouldn't apply to them. And the SEC was trying to make sure that this rule and this prohibition would apply to CLO collateral managers. Now, again, affiliates includes not just U.S. affiliates, but foreign affiliates. So large organizations who are really likely to have issues when different parts of the organization are not aware of transactions in other parts of the organizations. Another real issue is that banks and organizations that have information walls that by design are intended to prevent different parts of an organization from knowing about transactions that happen in other parts of the organization. The rule gives absolutely no, the information walls are effectively not respected for purposes of this rule. The rule explicitly excludes persons who perform only administrative, legal, due diligence, custodial, or ministerial acts. So lawyers and trustees would be exempted out of the rule. Okay, so let's go to the definition of conflicted transaction. It has two components. One is materiality, which we're not going to spend a lot of time on today. And the other is the type of the transaction. The type of the transaction includes not only the kinds of things that John Paulson did in the Abacus transaction, short sales and credit default swaps or other credit derivatives on the ABS, but also a catch-all that's really broad. It includes other transactions in which a securitization participant would benefit from an actual or potential adverse performance in the deal or a decline in its market value. So again, really, really broad potential. And that definition of conflicted transaction, we've all been spending a lot of time scratching our heads and coming up with different hypotheticals where we can't convince ourselves that that those transactions wouldn't be prohibited. I know Chris Horn's going to talk about the exceptions to that definition, so I'm going to move on to the applicable period. So there's a beginning date and there's an ending date. The ending date's easy. It's 1 year after the first sale of the asset-backed security, so typically 1 year after pricing. But the beginning date is, again, a complicated definition. It's when the securitization participant has taken substantial steps to reach an agreement that they will become a securitization participant with respect to an asset-backed security. So if you sign an engagement letter, right, 2 years before the ABS deal, I think the period has begun. What if you're an issuer and your parent company's board of directors, a year before the transaction, has approved the 2024 funding plan, and in the fourth quarter of 2024, the board has approved an asset-backed securities transaction? have you, by going to your parent company's board, in fact taken substantial steps to reach that agreement? Okay. Again, the anti-evasion period, likely to be a huge mess if it's violated, if the transaction that you do circumvents the prohibition. It doesn't require any intention that you intended to avoid this rule. It doesn't require any knowledge. Just, it's a gotcha in a subsequent sort of way. And then the comment period is very, very short. The comment period expires on March 27th, and all of the trade organizations are now, currently seeking extensions of the comment period. And with that, I think I'll turn it over to the next speaker.
Stuart, thank you very much. And as Stuart indicated, Chris is now going to speak to some of the exceptions that Rule 192 contemplates. Chris.
Right. Thanks, Paul. Yeah, unfortunately, these exceptions aren't going to do much to make us feel better about the parade of horribles that Stu just described. So we have in the statute that this rulemaking is arising from Section 27B of the Securities Act. It provides certain exceptions, risk mitigating hedging activities, exception for liquidity commitments, and an exception for bona fide market making activities. And so they take those exceptions and spin them out into this rule. Certainly, they're not adding any additional exceptions, but just going through each of those quickly, risk mitigating hedging activities, subject to a number of conditions. One is that the hedge is designed to reduce or mitigate one or more specific identifiable risks arising in connection with the holdings of the securitization participant. So the securitization participant is not permitted to overhedge or create a net short position with respect to the ABS, and the hedge has to relate to specific identifiable risks, not general risks of a speculative nature. The hedging activity is subject to ongoing recalibration during the compliance period to ensure that the exposure does not, with time, become overhedged. And the securitization participant has to establish and maintain and enforce an internal compliance program with respect to its hedging activities and adherence to the conditions. So that compliance program, it's required in order to take advantage of the exception, right? So even for a hedge that's perfectly innocent and in line with the substance of the exception, you still need to have the compliance program in order to be able to take advantage of the exception. And for the Volcker Rule aficionados that might be listening in, the terms of this exception might sound familiar. They're drawn, not word for word, but inspired by the same kind of exception in Section 5B2 of the Volcker Rule that applies to banking entities that do not have significant trading assets. The compliance program part, though, on the other hand, is coming from 5B1 of the Volcker Rule, which sets forth a hedging exception for banking entities that do have significant trading assets. So they're picking and choosing and being rather selective in how they're inspired by the Volcker Rule, and certainly lining this up with the Volcker Rule and risk retention and other places where hedging exceptions exist is going to be a key focus for comment letters that the industry is working on. We also have an exception for liquidity commitments, purchases or sales of ABS made pursuant to and consistent with commitments of securitization participants to provide liquidity for the security, for the ABS. And the SEC is soliciting comments on whether this should be expanded, including to cover providing loans pursuant to a liquidity facility that supports an ABS. And finally, we're moving to the exception for bona fide market making activities. This is subject to various conditions, of course, as is the risk mitigating hedging activities. And these are drawn also from a similar provision in the Volcker Rule, but again, of course, not word for word. Among the conditions are that the securitization participant routinely stands ready to buy and sell the same types of financial instruments, and is generally willing to facilitate customer needs by entering into long and short transactions throughout the market cycle. The market making activity is designed not to exceed the reasonably expected near-term demands of counterparties. So you can't use this exception as a cover for building a net short position. And so those close to the Volcker Rule may recall the Volcker Rule contains a rebuttable presumption of compliance with regard to this condition if the banking entity establishes certain internal trading limits. So this concept of the rebuttable presumption is not carried forward into this rule, which is another kind of example of the picking and choosing that I referred to before. Another condition is that the compensation system for people performing market-making activities can't reward or incentivize conflicted transactions. Securitization participant, another condition is that it has to be licensed or registered to engage in market-making activities. So what we're talking about, for example, are registered broker-dealers, licensed banks, and registered security-based swap dealers, according to the Commission. And then finally, of course, the securitization participant has to establish a compliance program to ensure that it's meeting the conditions. Again, no other exceptions, no safe harbor for foreign transactions. As Stu is mentioning, there's no exception for information barriers, for disclosure, so it's pretty bare bones. And with that, Paul, I'll turn it back over to you.
Thanks, Chris. Actually, I'm going to put you on the spot because maybe we could put a little illustration to the descriptions we've just provided. What are the sort of things which appear to be caught or snared by the proposed rule that we see as being potential activity that would have not really thought, one would have not thought would have given rise to a prohibition that proposed?
Yeah, I mean, one thing that comes to mind, if you think of an originator who hedges its portfolio of originated assets prior to securitization, I think some of this is going to raise a question as to what extent that hedge is going to be permissible under these rules, particularly if the hedge persists after the securitization closes. I think there are a number of kind of practical real world questions like this where we're kind of surveying the industry to see what people are doing and what regular way, everyday kinds of activities are going to be permissible or not permissible under these rules, and then calibrate comment letters accordingly.
Thanks, Chris. Leslie, if you could give us a few minutes on some of the unusual results that we've seen as a result of this rule being applied to registered investment advisors and other asset managers, and comparing it to the current treatment they would get under the 40 Act.
Sure. Yeah, and this is a really interesting subject. It's something that I think all of us have talked about, at least informally, since the proposal came out. And Chris, you and I have talked about this, even more so. And the idea here is that fascinating that this proposal goes well beyond what, for example, the Advisors Act would require, right? The proposal, as you just heard, we're talking flat prohibitions with limited conditional exceptions, but it's a prohibition-based rule proposal. And what's interesting is that stands in contrast to an investment advisor at its fiduciary duty to its clients, where even in that heightened sense of duty, right, that the idea that an investment advisor has to put its clients' interests in front of its own, right, and has to act at all times in the best interests of its advisory clients, even in that sort of heightened scrutiny context, disclosure and consent as a general matter is sufficient to address conflicts of interest that arise between investment advisors and their clients. Right? The Advisors Act has been, at least historically, interpreted as a disclosure-based statute, requiring full and fair disclosure, clearly, not just any disclosure, and not just any consent from the client, but it has to be informed consent. But generally, that's sufficient to what I would cure a conflict of interest. Little bit on shakier ground of recent because of the fiduciary interpretation and some staff interpretation subsequent to that ask advisors to mitigate or avoid conflicts of interest. But at the end of the day, even in that fiduciary context, which we don't have, right, between these types of issuers and their investors. Disclosure and consent is perfectly appropriate, but apparently not appropriate, not enough here. It's almost that they really took a page from the Investment Company Act, right, in terms of flatly prohibiting, or at least provide, and with conditional exceptions to certain transactions between, for example, registered funds and their affiliated persons.
Okay, that's great. Why don't we bring our presentation and overview to a close? I'm going to put Michelle on the spot now. Michelle, Stuart raised the anti-circumvention provision, which I think is generally regarded as unusual, particularly when it's applied to a rule as a whole, as opposed to more limited cases where it might be applied to an exception or a special category. I'm just curious if you have anything to add to Stuart's description.
Yeah, absolutely. It is a really broad provision that takes a rule that has some, while it has some other smaller catch-all provisions, has some very specific prohibitions on activities and parties, and then just says, and anything else. The way the SE puts it in the proposing release, it's the intent is to capture economically equivalent transactions. So it really just, at the end, sticks in this very sweeping catch-all that could really bring in a lot of transactions that people wouldn't even know to look for. Something that I think is interesting, though, is in one of the requests for comment, it asks, the SEC asks about if, and gives an example of alternative language that could narrow the scope of the provision by making it more intent-based, where throughout the rest of the proposal, they really try to stay away from intent. So, I'm curious to see where that could go in the future as the comments come in, if this is something that the SEC would be willing to look at based on this request for comment.
Yeah, that's certainly supported in the legislative history, which I read today. Maybe just again to close, deadline is now fixed. The rule is being published in the Federal Register, right?
That's right. The rule was published in the Federal Register, I believe, on the 14th or 15th of February. And so that means the deadline is now March 27th. And there has been a joint trade association submitted a request for a comment period extension. That request came in on Thursday, February 16th. So we'll see how the SEC responds to that, and hopefully they'll respond to that soon.
And finally, when would you have to comply with the rule if it's adopted as proposed?
As proposed, there's nothing in the proposing lease about a compliance implementation period before compliance would be required. But a lot of the rules, once they're adopted, the SEC does give some kind of implementation period between adoption and when compliance is required. And given some of the stuff that Chris spoke about earlier with the exceptions and various compliance regimes that are required to meet those exemptions, it seems like there should be some kind of period where different parties are allowed to change their policies and procedures to meet those exceptions. So, again, it's wait and see, but hopefully that's something that becomes reality.
I lied. I have one more question. You mentioned a number of trade groups requested an extension. That would indicate there's a number of them thinking about commenting, right?
That's right. The extension request that came in on the 16th has, I believe, about 12 trade groups listed, and there's even more groups I know out there and individual participants that I think we're going to see a lot of comments come in.
Great. Well, that concludes our presentation. Thank you all for listening. Obviously, if you have any questions about today's podcast or anything else that relates to today's subject matter, just send us an email. The email address is gfm@mayorbrown.com. And thank you again for listening.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayor Brown audio programming, visit mayorbrown.com/podcasts. Thanks for listening.